about Pennsylvania's Managed Long-Term Services and Supports privatization plan. And we're very grateful to have Eric Carlson back from Justice and Aging in follow-up to our initial webinar. I'm going to spend very little time on our introductory remarks. I had sent a lot of information in the invite that hopefully you've had a chance to see. And I do want to comment on the concept paper. Just very quickly, a couple of things. One is DHS made clear on one of their webinars that if something is not mentioned in the concept paper that was in the discussion guide, it sounds like they were having second thoughts about that, and you should include that in your comments versus assuming that it was just an oversight. One example I used in my question had to do with the Ombudsman program, and so that's something they seem to have taken out in this particular draft. Also, you probably all know by now, behavioral health has been carved out, and the LIFE program will be a separate program from this privatization plan. Comments are due next Friday, October 16th at 5 o'clock. If you would like to see CARIE's comments, if you want to email me, I'll be glad to email them as soon as they're finished, which will probably be very close to that deadline. Otherwise, they will be posted on our homepage for those of you who are just curious and want to see what we submitted. But if you want to copy any or all of our comments, let me know, and I'll be glad to send them to you. With that, I'm going to introduce, again, Eric Carlson, who's the directing attorney at Justice and Aging, which is a phenomenal advocacy organization for older adults. They recently changed their name from the National Senior Citizens Law Center. And Eric has a lot of experience working with other states on this issue. So at this point, I'm going to turn it over to you, Eric.
Terrific. Thank you, Kathy. We'll just spend a couple seconds going through the basics and then go into more of the specifics. As folks know, there was, as Kathy just mentioned, there was a discussion document a couple months back that was very general. Then the concept paper came out, and that's what we're dealing with right now. One of the explicit goals of the concept paper is to serve as a springboard for input from stakeholders. As Kathy mentioned, the due date for comments is coming up very, very soon, and then things will move relatively quickly after that. There's a request for proposals that's scheduled to be released in November, and you can imagine that the state is already right in the middle of drafting that. So it'll be important to make comments to see to what extent the RFP can be pushed in a good direction. And then implementation scheduled to begin in January of 2017 in the Southwest, and then phased out over the rest of the states over the next couple of years. I'll mention this broad point. I raised it in our webinar of a couple of months ago. It may be that the train has left the station or the horse has left the barn, whatever your metaphor is, but I think it's still worth challenging some of the assumptions here. At this point, I would say it's almost a certainty that the state's going to develop a managed care proposal. But I think it's important to still question why that is, if for no other reason than to force the program to live up to whatever the claims are. it's not necessarily, it's taken as an article of faith, I think, by a lot of states that, of course, this is better. You get all this coordination, you get integration, you reduce or eliminate a lot of the perverse cost shifting that you otherwise see, but it's not necessarily true. It's not a fact of physical nature that happens. Those are just assumptions that are pushed out there. And so, and I don't know in a lot of cases whether states that are in the middle of this have the data to back it up. So it's worth asking for that to push this in a good direction. The basic structure of the program is laid out in the concept paper, 2 to 5 MCOs in each region. Each MCO has to offer a companion DSNP, right? The Medicare plans that are focused on dual eligible people. I talked to some of our people that focus more on the dual eligible integration, and their general sense of that was that there wasn't a precedent that they knew of off the top of their head with this model, that it would be some kind of positive, though, if it makes it more likely that you're dealing with plans with a more of an expertise with an older population and obviously with a Medicaid population as well. One of the problems that we've seen in a lot of states is that managed care programs are getting into this without necessarily knowing much about Medicaid. Their expertise is by and large, is less so now, as obviously as the Medicaid programs are getting bigger and bigger. But still, in general, a lot of these plans are much more familiar with the private market and less familiar with Medicaid, less familiar with LTSS, and so there's some benefit in asking for that additional expertise of the DSNPs. The concept paper explains that there's replacing the 6 current HCBS waivers. You folks obviously know more about those than I do, and I'll just raise the question because I don't know the answer. I don't know if waiting lists have been an ongoing issues in these waivers recently. I didn't see anything about that in the concept paper, but that's obviously
Eric, I can jump in quick. There are waiting lists with most of the waivers, with the exception of the aging waiver. However, there's huge delays in terms of the application process for people to actually get started with services. So, and I don't see that that's going to be addressed with this new provision. I just want to quickly say, too, that at any time, please submit any questions via the chat function, and we'll be getting to that at the end of Eric's presentation. Sorry for the interruption.
Oh no, I appreciate the not the interruption, but the additional information. So I just raised that as an issue. I didn't see it dealt with here, and obviously, if you're talking about access to LTSS and rebalancing the wait lists and the delays are a huge problem, and you'd want to see that if the state's serious about rebalancing. You saw some of the introductory language here about raising the state's ranking among other states in balancing LTSS, in balancing HCBS versus facility-based LTSS. If they're serious about that, what you'd want to do is reduce or preferably eliminate the delays that the current system have. And one other point I mentioned before we move on, talking about choice, that two is a choice, but it's not much of a choice. That the viability of how many MCOs you have depends a little bit with the realities of the area and the population and the population density. In general, the rule as to MCOs and providers is probably the more the better, but again, subject to the realities of the area. Kathy mentioned this, that behavioral health is carved out, but otherwise Medicaid covered services are included, and the duals would have the option whether they'd sign up for a DSNP as well. According to the concept paper, we're talking about almost half a million people, including a significant number currently receiving LTSS, and then obviously there's another very significant number of people who are not receiving LTSS, but who are duals. These are the goals listed in the concept paper. Hard to argue with these. It's the typical language about, you see opportunities, the care coordination, improving quality, improving efficiency. The devil's in the details. So on with some of the specifics on eligibility determinations. The financial eligibility, which is, as you would expect, continues to be dealt with, of course, by the state and the county as opposed to the MCOs. On the level of care eligibility, there's discussion of a standardized level of care tool and evaluations done by a contracted entity. That sounds to me like a positive thing, depending on, of course, what the standardized level of care tool looks like. And then also, I don't know the current reality, so whether that's significantly different from the current system, I wouldn't say. In general, although on these assessments, I think our take, the legal services take, is you want some level of standardization, assuming that it's a tool that works. You're better off with some level of certainty and a tool that doesn't lend itself to too much ambiguity. That you ideally that you've got results that can be that are solid and can be duplicated if somebody is reassessed by a different person in a different area of the state, for example. But the specifics there are obviously important, but the basic model seems to make sense. Going on with the assessments, are going past just the level of care assessments, but beyond just determining whether somebody's eligible for LTSS, and to see what kind of services they might be eligible for. First, there's a mention of need screening and analysis of participant utilization. I'll confess, when I see analysis of participant utilization, I'm not exactly sure what folks are analyzing. This seems to read like the people are being assessed to the extent that they might need LTSS. My sense there is that a lot of times you don't need a real rocket science type of evaluation to determine when somebody needs it, and what you want to have would be a system that really lends itself to requests from people. A lot of times just personal knowledge of folks may give you some sense of whether they need LTSS without this additional analysis of participation of utilization. Some other folks may have a better sense of what that might be, but if you had a process, I think it would be the best thing to do is if there's some kind of personal connection. In the absence of that, you wouldn't want to see numbers that floating around that didn't mean anything or weren't effective. If the need for LTSS is identified, then there's a assessment of folks. So if you assume that somebody needs LTSS, then you have an assessment based on a standardized tool. This, I'll say, also strikes me as a positive thing compared to what else you see out there. In a lot of the states in which you're working, there's not that level of standardization. There's real confusion as to how the assessments are being done, and lots of claims by MCOs that their particular assessment tools are proprietary, which gives you these odd situations where you're in a hearing and you can and being forced to argue with the MCO over getting access to the very tool that's supposedly determining whether or not your client is going to be able to receive the services that he or she wants. So that, I think, is an area to emphasize. Just in practice, in too many of these states, this kind of stuff does get pulled behind a curtain, and the MCOs aren't eager or even willing to share that information. And so, to the extent that it's standardized ahead of time, developed out in the open, presumably, as you'd hope, if there's enough input, would be developed in a way that's reasonably fair and accurate in determining eligibility for services. That would be a really positive thing. I'm not the last word on assessment documents. If folks are interested, I'd certainly be willing to poke around. I know other folks who know more than I do, but it's an area that deserves some advocacy, given the importance of the assessment documents and the assessments. So the other feature that's good that's mentioned in the concept paper, because it talks about considering the availability of unpaid caregivers. I'm also aware of hearings in other states where one of the big issues is just the automatic assumption that if a caregiver is there, that they're available and they're substituting for what the Medicaid program might otherwise be obligated to pay. And so it could be a little bit clearer, but at least it is still with relatively little detail, the fact that it talks about that being an issue that's in play is a positive thing. Next step beyond assessments is the care planning, the service planning, and there's certainly some good things here. I guess these are the things that it's very easy to look good, because some of these are those type of assertions that can be made without a lot of specifics, right? We're going to address preferences, there's going to be expertise, we're going to address needs, we're going to monitor, we're going to evaluate, we're going to share. I mean, all of that is really positive. As I'll mention in a second or a minute or two, in all these person-centered planning, the issue is how you make sure that that's the way it happens in practice, that this flowery language at the front end about addressing preferences becomes a reality. And probably the key is, one, to have some ability to appeal or to challenge, to make sure that the beneficiary really has a strong role, that it's not, the process isn't dominated by the service planner, the service coordinator, and we can just go on to discuss some of the specifics. Also, the service coordination is only required for LTSS, and it may be provided for others. I've listed some of the examples here, and you may want to argue that those should be required rather than optional. There's a good mention of care transition protocols when people are going out of hospitals. There, probably the issue is, well, what does that mean? Yeah, you have a protocol. If there's a way to address, what would you want to see when someone's going in and out of a nursing facility? Like the proposed nursing facility regulations, for example, that are on the federal side, are putting more of a focus on discharge planning. So, maybe something like you'd have a protocol that would require those things to be identified, give people advance notice what the possibilities are, and give it some thought. But just the fact that they're required to have a protocol isn't as useful, obviously, as knowing something about what that protocol might be addressing. And that's going to be you can already get that sense that that's maybe the biggest takeaway from all this discussion, is that the managed care, and we'll see that particularly when we talk about quality here, there's a lot of requirements that MCOs come up with protocols, come up with policies, institute procedures, however it might be explained, but without a lot of specificity of what the ramifications of those policies might be, and then also without much transparency about whatever those protocols or policies or procedures might be. So at the back end, 3-4 years down the road, if you're wondering what's going on, you'd want to know what those protocols are and what they're doing. So at a minimum, ask for some basic features of these protocols, or demanding some level of transparency, and that's not just, you would hope, sharing between the MCO and the state, but sharing in a way so that you and I, our clients, have a real sense of what the MCO has obligated itself to do. I thought that in this particular area, the specifics of the planning process, that the concept paper was weak. I'll say you may get a sense of it that in multiple areas, this is actually better than I anticipated. I'll mention a few things where there are consumer-friendly provisions that I didn't necessarily anticipate. This is not one of them. And I was surprised, particularly because there seems to be so much momentum these days about talking about resident-centered care, person-centered care. The federal regulations have been strong on this, and I see more states getting on board and going along with that momentum. But this structure seems to be much more focused on the service coordinator and is not set up in a way that would give the individual enrollee a tremendous amount of control. So here's the language. The service coordinator would develop the service plan during a face-to-face meeting with the individuals. You could just get a sense. There's nothing from that indicates that it's person-centered. It may be called person-centered, but it's not, and there's no mention of appeal rights. And you can compare it to the person-centered planning regulations. These are the regulations for Medicaid HCBS that became final at the beginning of last year. I've listed the citation there. It has to be the process is led by the consumer whenever possible. It includes people chosen by the consumer. There's information support for the consumer. The idea is really that it's really supposed to be person-centered. The person's supposed to figure it out. The LTSS in particular is not necessarily comprised of clinical services. It includes a lot of assistance with ADLs and other things that aren't necessarily driven by physicians or they are driven by or should be driven by what the person wants. And he or she is in a good position to make some decisions regarding that. So that, I think, is a point that should be made, and a point that's probably will find a fair amount of receptiveness within CMS, for example, because in general, not across the board, but in general, they also claim to be or are on board with the relatively strong movement toward person-centered care. Some of the issues here on the person-centered planning, we've addressed a couple of them already. The assessment tool, it sounds like it should be more standardized in public. You'd want to make sure that that's true. When you get to the specifics, you'd want to make sure that it addresses the caregiver availability. One of the important issues, which if Pennsylvania did this well, it would maybe be the only state that has done that. I just recognize that this is a tough go. Some ability to appeal these care plans. Now I don't have any good models for you. The goal is that enrollees don't just get railroaded during this process, that you want to set it up in such a way where you get a service plan that really does reflect the goals and preferences of the individual. Now, how does that happen? And no system's just going to give a piece of paper to the individual and say, okay, just tell us what we should do here. But there should, ideally, you get some balance where the process would have enough balance to it, enough respect for the individual, and enough ability to integrate the opinions and input of the individual, that's where you'd get. So part of that is looking at those person-centered, say, the federal rules, and figuring out how to include people that the enrollee wants, and to make sure that he or she is driving it to the extent possible. You'd probably want to be as specific as possible so that the enrollee wouldn't just get bulldozed in the process. And then some ability to appeal it. And again, there's no good models there. There's a question then of if the beneficiary just drove this thing, why should he or she be appealing it? But that's a safeguard to make sure that he or she doesn't just get pushed around during the process. So that would be an important protection if you can get it. And obviously the contents of the care plan are crucial, and there is a real risk that the enrollee will get pushed around in the process, and you'd want to get some ability to be able to take some of these questions to an outside person. There should be transparency that it goes along with what the assessment tool looks like and how the scoring is done. I don't know enough about Pennsylvania to say if you have a system like that right now and whether it works or doesn't work. To the extent you do, it could be brought across. To the extent you don't, you may want to look for something with more specificity. And I'll mention here that talking about the independence of the service coordination, it says it can be provided by community partners as long as there's expertise. You could imagine that being a really positive thing if you take that away from the MCO. The stereotype here of the bad MCOs or MCOs that are just making these very short-sighted, cost-averse kind of decisions. Maybe a community partner, if you had an independent person that would be driving this, that would be a very positive thing. Whether MCOs would accept that is another question, particularly when you talk about managed care. Part of their management is making these kind of decisions to a certain extent. Some of the service coordination issues that are also mentioned during the concept paper, that what the service coordinators are doing this monitoring, making themselves available during regular business hours, and having some ability the MCO having some ability to address inquiries even after hours. And there's a mention of the care transition protocols as well, which we mentioned earlier. Talked about the independence of the service coordinators, and we also talked about the transition protocols and what in the world that means. You'd want to have more specificities there. The system provides some support for enrollees. I thought a lot of these were positive, and things that I don't know if I've necessarily seen in other states' programs. At least it didn't jump out to me as something that's completely standard. The availability of translation services seemed to be a little more automatic without the line drawing over the prevalence of languages within the population. Fourth grade reading level is lower than you see in some of these requirements, which I think is a good thing, just to make sure that people are able to process the information. And again, this mention of alternative languages and formats was less qualified as what I've seen in some other states' proposals. On the LTSS benefits, there's a long list of benefits. I'm assuming that there's nothing new here, that it's what's being carried over from the existing waivers. There's also mention of the extra benefits. I've had some experience with this in other jurisdictions, including California, and our general experience is that they haven't been very available, just because of the nature of being extra. And I don't know if I have a great suggestion here. You'd like to establish, the best thing to do would be to establish some kind of entitlement for them. Then, of course, they wouldn't be extra. And maybe that's a matter, I don't know enough about the existing service package to say what's missing that should be included. Maybe that's the best response here. I'll just say that there's maybe nothing harmful with this discussion of extra LTSS benefits. Of course, an MCO is able to provide more than they're obligated to do, preferably in situations where it would be a win-win situation, and the provision of the services would benefit the enrollee and prevent deterioration, for example. But you'd want to think about it and maybe not give the state or the MCO too much credit for putting this in. At least in practice, I think we've found that it's difficult to get much mileage out of these kind of requirements for reasons that you can probably understand. This, I thought, was a positive thing, the reference to transition services. It was just unclear here exactly how this would play out, who's paying the money. It goes along with the financial incentives. Part of the issue is in rebalancing is to give MCOs a financial incentive to move people to make HCBS available, legitimately available, as an alternative to facility-based services. A couple points there. One is that there's a mention of identifying people who are appropriate for transition. You'd also want to have some ability for people to identify themselves. They shouldn't just be sitting around waiting for someone to identify them through some sort of algorithm. They should be able to put their names forward themselves. And then secondly, in the comments, it's worth talking about the reimbursement rates and how the capitation is handled. For one of the issues on rates is making sure that facilities MCOs are paid the same, are not paid extra for nursing facility residents in general, because otherwise they got an incentive to move people to nursing facilities as opposed to providing home and community-based services, but also not to it goes both ways. You want to give the individual as much control himself or herself. There are certainly situations where our clients may prefer to be in a nursing facility under the circumstances, and so you don't want the incentives to be too strong, and also it's worth thinking about the cost thresholds that may be imposed in some circumstances. I again don't know the current reality in Pennsylvania, and whether there are current cost caps on the waivers, and whether those caps tend to be in the aggregate. Right, your average can't be higher than the expense of nursing facility care, or whether it's more individual, that not any single individual can have in a waiver can have costs that are higher than the equivalent facility-based service cost. But I'll mention that it's probably worth making those sort of points now. The earlier the better. They're incredibly important into how the providers act in these circumstances. And if an RFP is going out, that means that there's going to be a lot of specifics laid out there for the MCOs and down the line the providers. And it's worth specifying those things later rather than having them laid out by the state and trying to reverse something that's already been set. On self-direction, there's 3 models that are mentioned. I'm assuming that these are consistent with what the state has now, but of course I don't know that for certain. The agency, the employer authority, and the budget authority, where the individual has more authority to move the money as he or she chooses based on his or her preferences. The good thing of allowing people to hire family members or friends as caregivers, so it appears to be a fair amount of discretion here. Again, I may, of course, defer to you folks who've got more experience in state. In general, our experience has been that, and you can understand why this is, but then self-direction has been a tough fit with MCOs just because it goes against the model that some of the ADL providers, the personal care providers, have difficulty dealing with the MCOs. There's some conflict with the care coordination process, and so it needs to be set up in such a way where that the person really does have control over the process as much as possible, and it is not excessively dictated by the managed care organization. You can see something positive here to trying to make it work for the smaller providers. There's a mention here of the financial managed services vendors and the MCOs being required to contract with these folks with an effort to make sure that the providers in those systems, that the enrollees are not overly burdened with whatever the financial logistics may be. Talk about enrollment briefly. Going back to when the person is entering the MCO to start with, that there's a discussion of an independent entity, more of an enrollment broker. They would advise people. This is a fairly common feature these days, and the stage notification is typical as well. It's what you generally see in these programs, that there's an initial notice 3 months out, and then another notice 2 months out, and then another notice after that, and then what's likely a default passive enrollment if the person hasn't made a choice by the specified time. This appeared to be a fairly standard format, this intelligent assignment. The default, if person doesn't make an affirmative choice. The reasonable decision, I think, if somebody's already enrolled in a DSNP, to have that person enrolled in a Medicaid MCO that's the companion to the DSNP. The state is explicitly asked for input on factors determining this intelligent assignment. the most obvious one here is who the person's provider is. That our experience has been that people really are attached to their providers, regardless of what area you're in, even if you're in a big metropolitan area where it maybe these are people that you know incredibly well, but that really seems to drive people's decisions for one MCO over the other. So for my money, that would certainly be a huge factor. I don't know if the state said anything or much about that in this concept paper, but one of the big points I think would be to look at who the person's providers are, and assuming that they want to keep those providers as much as possible, and so having this intelligent assignment refer them to the MCO where the person is in network. Just a mention here. Here's one area where at least the proposed regs are a little bit better than this. First, to mention that can't do much about the enrollment to Medicaid MCOs. It can be mandatory. The federal government can't require enrollment in Medicare managed care, but it can require enrollment in Medicaid managed care. The proposed federal regulations suggested an improvement so that people on their passive enrollment, which is a euphemism, of course, passive suggests that it's a very benign process. It's really an automatic assignment, even though you didn't make a decision. But the proposed federal regulations called for at least 2 weeks of fee-for-service prior to passive enrollment in a Medicaid MCO for people who are just becoming eligible for the program in the first place. I know providers spoke loudly against this. They don't like it, but at least that's what was in the proposed regulation. So there's some room for arguing here that people could, in moving into eligibility, get fee-for-service for a little bit of time first, some type of phase-in prior to the movement into the managed care organization. Here's a provision that is one of those that's better than normal, I thought, that I'm much more accustomed to lock-in. You can see on the bottom of the slide it talks about the federal regulations where under the proposed regulations, the first time you enter an MCO, you could get out during the initial 90 days, but after that, you could only get out annually or any time only with cause. But as I want to, part of me thinks this concept paper can't be right. It seems too easy, but and maybe I missed something. But as my reading, it seemed to talk about being able to get out immediately and have the effectiveness be really rapid, either at the beginning of the month or the middle of the month. That strikes me as very pro-consumer and much better than what you see in most other states these days. Network adequacy. Here we enter the sort of things where I think it's much harder for me, maybe harder for you, to talk with a lot of specifics. I've been to a fair number of conferences and other settings where CMS has spoken, where MCOs have spoken, state officials, and I know I've asked multiple times about, well, how are you measuring adequacy here? What standards that work? And I have never gotten a really strong answer from anybody. And some folks have said, I think this is maybe the most accurate thing is, well, you know it when it's inadequate. That you can tell that there's no adequacy when people aren't able to get services or aren't able to get services in a timely fashion. Again, all of my discussion of this, along with the performance measures, just indicates the difficulty of dealing with the MCO and the state on these kind of measures that are heavily technical and driven by numbers and algorithms. The cynical side of me says that they don't know anything more than I do and are just churning out numbers that aren't really that substantive or that accurate. But I can't say that for certain. But I can say so. In content, then I don't really know what to suggest for LTSS. That these time and distance standards don't seem to work. I don't know of a good. Maybe the best thing is if you could do something with real access. Like some people you see mention now of surveys, secret shopper surveys essentially, or physically calling and seeing if people are available. Something that tries to get to the core of it rather than relying on algorithms that may or may not make sense. So anyway, part of this is editorial, but I find the network adequacy discussion very difficult particularly in an LTS environment because it's not transparent, and there's so many readiness problems. You see states come out of the blocks and then fail, that you have a sense that maybe the states or CMS don't have a complete control over it either. There's some good standards here, talking about culturally competent providers, talking about requirement of approval for material changes in network, and then there's a lot of good language here. I'm summarizing it extensively at the bottom of the slide about provider support, services, training, and particularly the provider representative within the MCO, and that struck me as a relatively unique thing. I don't know if in other programs whether I've seen a designation of a particular person as being the contact for a particular provider within an MCO. This slide just goes back with my previous point. All these bullet points of things that the MCO has to do. I think you could ask for transparency here. I think that would certainly be one important step to be able to evaluate these things and to make sure that they're meaningful and to be able to assess what went wrong if something does go wrong. Otherwise, it seems a lot of times like this black box type of situation where for you and I it's difficult to evaluate what's going on. The one mention I will make here is something that I can definitely understand without having a PhD in health policy. Asking that providers return calls within 3 business days strikes me as a really weak standard. We certainly try to return calls within 3 business days, and I think in the healthcare model, you people should be expected to do much better than that. The questions here, the questions that I just raised, it's difficult to talk about specifics. Maybe transparency is the best we can do. I don't have good suggestions for solid standards, but I'd certainly defer to others who maybe would have more expertise with that. There's some good continuity of care, so maybe not good continuity of care, but fairly standard. 6 months. The negative thing here is that sometimes continuity of care, these continuity of care provisions are limited to whenever there's a new service plan, and so there's for a person who's transferring, it could be really abrupt, and they could lose their service provider in a big hurry. So there was less in here about recognizing the need to retain additional current healthcare service providers. There's much less than you've seen in other states. To the other things, it's probably, and also I'd say 6 months, accept all willing and qualified LTSS providers. I think I've seen longer periods than that, a year or at least a year. That strikes me as relatively on the limited side. A good provision here is that you need to get state approval of service plans, it reduces any one service by more than 25%. Maybe you could ask for a better standard than 25%, even 10, 20%. That's pretty significant as well. 25% is a dramatic cutback, and I think you'd want to set a more a broader net there, because that certainly has been a problem in a lot of states that we worked with. MCOs come in, all of a sudden there are these cutbacks, and for no particular reason, and you'd want the state review is good. The transparency, I think, would be better, and some real specifics about how you measure what a percentage cutback is. And there may be some other ways of identifying what are overly large cutbacks as well. There's a provision that allows people to stay in nursing facilities indefinitely. Maybe there's some other provisions that other settings where that kind of continuity would be just as important. HCBS provided in residential settings, for example. I'll defer to you folks in Pennsylvania as to what extent those situations may be, or potentially some other settings as well. So those are worth thinking about, this idea that, the nursing facility is the most important. You can imagine other situations where that kind of continuity could be crucial. There's some continuity of care provisions relating to transfer of one MCO to another. I think the same point that we made in the other slide continue to be valid. Well, about the value of retaining a provider, for example, even if there is a new service plan. I will say that there's very little here about appeals, as important as those are. This, I think, was maybe the only significant discussion of appeals, saying it's the same as you have in HealthChoices right now. There's a discussion about integration of Medicare and Medicaid, but not much more than that. There's a lot of discussion there. You'd want, for example, to address whether or not, how the fair hearing position, and again, I don't know what's going on in HealthChoices right now, but to the extent it's inadequate right now, or that exhaustion with MCOs is or is not required, and that's a problem, all of those things are worth raising now. As far as integration goes, I talk to people here who are more familiar with the dual eligible integration states, and they tell me that New York is the one state that's tried to integrate it, and that's what they're doing there. There's an internal plan appeal. The state administrative hearing unit is prepared to apply Medicare and Medicaid, and then evidently the Medicare Appeals Council is able to apply Medicare and Medicaid law as well. But there's very little history here, because they've only heard 5 appeals thus far, so it's hard to say what's going on. An emphasis here on home and community-based services. There's various mentions throughout the concept paper. I think we've addressed some of these things. How do you make it more specific? What we would want, I think, from a legal aid perspective, is that the enrollee gets some control here, that you don't have cost thresholds that dictate things too heavily, and is within reason that the individual has the choice of the setting in which he or she is going to receive care. A long discussion of quality management. I'll make the point I made. Transparency is a real problem here, to the extent that they're relying upon these measures excessively. It takes away the focus on individual enrollees. And as a practical matter, if quality measures, assuming they have an impact, and it's unclear that whether that's true or not, they have an impact years down the road. And you and I and our clients need something that's much more immediate, and we need much greater transparency here. There should be an understanding of what's going on. And I would even say that I don't even know that sometimes there's just too much. There's so many numbers there that nobody pays attention to any of them. And it's always easy to say we should get more and more and more and more measures, and when it comes up for conversation, You hear more and more. It's hard. Everybody's got an idea of a new and different performance measure, but I don't know if I've carried this out in my own advocacy, but part of me thinks if I had control over the process, if I had control over the system, I think I'd focus and pick some smaller number of measures and try to pick something that actually mattered and set up a way that you'd actually pay attention to those things. Because otherwise the danger is you've got all these numbers, they're floating around for years and years, and you and I never see any of them, and it's unclear that they make a real world difference. The state mentions there are some great goals here: access to housing, integrated employment, expanded LTSS workforce. You should take them up on that. And I don't have any, housing. The great answer would be to pay for it. It's unclear whether that's going to happen, and I'll defer to you on the specifics. But just mention that the state's asked for input. Try to be as explicit as possible. Do the state's work for it. I think it's always a good idea to the extent you can. My own skepticism about performance measures and a suggestion to focus as much as possible on how things play out for individual people. And we'd be happy to help down the line. We've got a lot of information on the website, on MLTS contract library, on the MLTSS toolkit, and I've enjoyed doing this webinar and the previous one, and would be perfectly willing to speak with you down the road and help however I can.
Well, thanks so much, Eric. There's so much information, and I'm glad you did highlight and have those links on your slides, because your website also has great resources that are helpful for advocates to use. I wanted to move on to questions now, and we will spend a few minutes, and we'll start with the ones that have already been submitted. But again, if you have questions, now's the time to submit them. I did want to point out that one of our participants mentioned that the ABES waiver did end in Pennsylvania on September 30th, and those folks were moved into other waivers. A question for Eric. The Pennsylvania advocates have been trying for some time to learn what waiver authority Pennsylvania is planning to use to seek for their MLTSS plan, and we're assuming it's going to be through Section 1115. And the person questioned, do you agree? Can you comment about timing, especially the state seems to be releasing the RFP before any explicit authority? And related to this, what exactly does the federal government have to approve? Is it capitation rates and other financial incentives? And can you say more about who is in charge and what they're be looking for in terms of these MLTSS plans?
Okay, so the two basic models, I would say that the most common models in the Medicaid are these combination 1915B and C waivers, and then the 1115s. And I think the 1115s are more attractive to states these days, just because they're demonstration waivers, and so you arguably might get away from some of the specific requirements that the B and C waivers apply. Although I'll say that CMS, it's not a complete free-for-all. There's a lot of precedence in these demonstration waivers, and you make the waiver application, and then you get back a terms and conditions document from CMS after negotiation, and there's a lot of boilerplate that's shared in all these states' demonstration waivers. So you'll see a lot of the same language over and over again, and it's worth looking at some of those, like New Jersey most recently, Kansas, other people that have gone through this process. You can see what some of the boilerplate is. So I don't know if it makes in 1115. One good thing, there are explicit transparency requirements in the regs, so you get a clearer opportunity to comment both to the state and to the feds based on those comment requirements. So that's a positive, but the negative is that there's a little less uniformity and arguably a little more risk of losing some protections, particularly if you had a CMS that was inclined to go in the wrong direction. Right? I mean, this administration, I think, is likely to retain 1915C concepts even in a demonstration waiver. If you had a different administration, the risk would be greater in going through a demonstration waiver, just because there's more discretion on paper for the states and CMS. And if I can try to pick off another part of that question, everything's in. It comes in play. The rates, for example, and how the capitation is done. I think it's certainly worth thinking about that. Sometimes we're maybe not as expert in some of those concepts, just because it's between the state and the feds and the MCO, and it's not a direct relationship with the provider, but with the enrollee rather, but it certainly has an impact on the enrollee. So it's worth commenting on. I think particularly about those basic concepts of when rates are the same, what you adjust rates for, how it affects rebalancing, and then you may get to some more specifics about the kind of changes that you make for performance measures. Or the other thing, I think about it, that didn't come up in this concept paper, the federal regulations propose a loss ratio of 85% to require to make sure that the MCO puts an appropriate amount of its resources into actual care provision rather than other things, and that's certainly something that's worth raising.
And the process and the timing of the fact that they're forging ahead with an RFP even before they ask, formally apply through one of these authorities, is that any kind of an issue?
No, I mean that you just see that happening. I can't give you a real great legal answer. All I can tell you is that the general idea of things happening even before final approval comes down is not unusual. And of course there's communication going. I mean, that's the other thing, that the state's talking to CMS already, and they're talking to the MCOs already, and we're not part of those conversations, but it's happening. And so there's these things going on behind, out of our view, and so and I think that drives this to a certain extent. These conversations are going on. They are working on things, and again, that's not my lawyer answer. I don't know if it's whether it's challengeable or not, and what the arguments would be, but just my sense of how it plays out in the real world is that you do see lots of situations where there's all this development going on, and there are calendar dates set, and we're going to do something by such and such a date. CMS approves it at the very last minute, and off they go. Again, not a great lawyer answer, but that's what I see happening.
Okay, and I have a comment here that, and I think we all agree the appeal language is too vague, and since New York has a more fully integrated approach to combining Medicare and Medicaid than Pennsylvania is proposing, do you think that's a viable approach?
Yeah, again, there's not a track record there. It's just so you don't know in practice, how would the Medicare Appeals Council handle when it gets a Medicaid issue. I'm not sure that it has discretion, but there's evidently folks have figured that out. I'll just say that on the appeals issue, that one thing we didn't talk too much about here is how much you get sucked into an MCO appeal as opposed to a state fair hearing, and I can leave that to your discretion. You may have your own opinions on that based on how it plays out in your state. But just putting that aside for a second, I think the integration makes sense. I would, of course, advise you to talk specifically to the New York people. I think our take is that it's a positive thing, but it's still early to say exactly how it's going to play out.
And also, could you comment on other MLTSS states' experience, whether new residential options like assisted living has happened as a result of MLTSS? For example, Pennsylvania currently doesn't have an assisted living waiver, but it seems like that might be opening up now as a result of this process.
I'll say that I've heard it said multiple times that theoretically, at least, an MCO system should be good for something like assisted living, because maybe even absent a particular authority, an MCO might look around and say, well, we could put this person in a nursing facility and pay $8,000 a month, or we can pay $5,000 a month in an assisted living facility or some other kind of residential setting. So theoretically, it would encourage that. I think in general, I haven't seen that, and I know, like in California, the assisted living people or the MCO people say that they've been gummed up by whatever the capitation rules are. So I think it could be done, but you'd want to make sure that the money made sense, or otherwise it might not happen. And it is an opportunity to write it in. You've got a waiver going, and so you don't have to open up a brand new assisted living waiver. But probably the thing to do is to, at this point, is to suggest it if it's a new benefit. I think if it just goes in the category of a quote unquote extra benefit that could be provided, it may never happen or rarely happen.
Is there a particular LTSS assessment model advocates should advance? Yeah,
good question. Why don't I check with somebody who knows that better than I do, and see if she has any suggestions.
I can get that out to everyone. Can you comment at all about how much Medicaid MLTSS plans are allowed to market to members? Can they push members to join their company's DSNP, or their rules, any rules, or can DSNPs push their members to join Medicaid MLTS plans? The person asking this question, is this especially relevant since Pennsylvania is proposing MLTSS enrollees can change plans at any time?
Right. Let me also put that in my category of getting back to you on the specifics. I know I've spoken to people on that, and I know that I recall it had been a problem. That the problem is that it breaks down some of the rules that MCOs generally have about essentially cold calling people. I mean, that is another thing. There wasn't any discussion. That's a good point. There wasn't any discussion here about marketing, and you'll see much more discussion of marketing restrictions in a lot of MLTSS plans. And it is a problem like this when, for example, the MLTSS program otherwise wouldn't be able to pitch to people cold or due to door-to-door or anything like that. But then because somebody's already a member, it has a green light to promote its own companion program. But let me double check with a couple other people here and see if I can get back to you with a little more specificity.
Are there any states that are good models that are actually measuring quality of care and quality of life in a meaningful way?
Yeah, good question. I'm not the last word on that. I think the answer is no. That the quality measures for quality of life are still largely in development still. The quality forum is working on it. Nashwood's working on it. The core indicators that are particularly common used in ID or DD programs are out there. But I don't think there's anything solid that really says this is the way to go, or I'm not expert enough with it to say. But I don't think it's necessarily my lack of knowledge. I think that the general consensus is that particularly on that LTSS is a real black hole for quality measures. That people are more comfortable with the HEDIS measures as far as measuring clinical quality goes, but LTSS is a new thing, and particularly there aren't the obvious clinical measures. The quality of life is murky as how to measure it, and the goals are not as obvious either. So I don't think there's a gold standard right now. People are struggling with it.
One last question before we wrap up is someone wrote in great points about the network advocacy. We wonder what kind of choice should be available for persons seeking nursing home care. Is the analogy comparable to the time and distance standards for PCPs and specialists, or is it more comparable to building a hospital network which is much less stringent than time and distance requirements?
For nursing facilities?
For people to have nursing facilities.
Yeah, I mean, if I understand the question, I think you'd want people to be able to stay in their community as much as possible, and so if that's responsive to the question, I do think that this kind of time and distance issues are important. You don't want to pull people out of their communities if you can help. I mean, using community here, even though I'm talking about a nursing facility. So if that's responsive, I think you're looking for more of the personal care model as opposed to a hospital model, because this is where people are going to move to and stay indefinitely, and so travel issues are a real issue if you expect them to get visits from family and friends, and to just get out in the community. For that, go ahead.
No, go ahead.
And I was just going to say, in a nursing facility, to get out in the community as well. I was falling into this trap of saying, oh, you're in a nursing facility, you're just getting visitors. You want people to be able to get out, and there's a focus in nursing facilities about getting people out as well. And so both to accept visitors and also to get back into your neighborhood to the extent possible.
Well, I want to thank you for extending your time and sharing your expertise. This is very challenging for us all, I think, to respond to the concept paper, particularly since it is very light on details in this short amount of time because there's so much at stake, and we really appreciate all of your help and support. And with that, I'll conclude the webinar, and if anyone has other questions, feel free to contact me, and we'll be in touch with Eric again. Thank you all so much.